I'm Susan Grissom with Grissom Law Firm. We're a firm located in Johns Creek, Georgia. I'm licensed to practice in the state of Georgia, and I focus my practice in the areas of estate planning, uncontested probate, and small business law. Today, I want to talk about a question that we hear occasionally, which is, I have a will, so my family won't have to probate, or why do wills have to go through probate? There's an assumption that if we write a will, everything just passes without the need for anything to actually go through the probate court. And I want to talk about that because that's not true. It could be true in some instances if all your assets have beneficiaries or joint owners on them, but in other instances it's not. So I want to talk about some of the classes of property and how they pass and whether or not that will is actually going to go through the probate process. The first type of property that I want to talk about is real estate. If I own real estate and it's jointly held with rights of survivorship, then if the other person who's named on that piece of real estate is living when I die, it does pass to them outside of probate. It doesn't pass under my will. So if I've named someone else to receive it, they're not going to receive it. It just automatically passes to the other owner. However, if my name is on a piece of property as tenants in common, in other words, Susan and Karen with no rights of survivorship, and I die, half of that piece of property just went into my will and is going to go through probate. In that instance, the joint owner owns their half, and then your will is going to dictate who gets your half, and it will go through the probate process, meaning that your will need to be introduced to the probate court, and ultimately your executor will then transfer the ownership to the beneficiaries that you've named in your will. Other assets, life insurance, financial accounts, for instance, these all have the ability to name beneficiaries on them. If I have beneficiaries named on them, then they flow outside of the probate court because they go to those named beneficiaries, as long as the beneficiary isn't my estate and as long as the beneficiary is living at the time of my death. If I have accounts that have joint owners, my brokerage account or my bank account, for instance, those assets are going to flow to that joint owner when I pass. They'll receive that as a matter of law. Then we can look at other things like savings bonds. If I have savings bonds and they're jointly held, then they're going to pass to the individual who's jointly on them. If they're not, they'll flow through my will. They'll go through the probate. If I have financial accounts, such as Treasury Direct accounts, if I have IRA accounts, if I have annuities, if I have other things where I've failed to name beneficiaries, those assets might flow through the probate of a will as well. If I own a business and I've got an agreement in place that says how that's going to pass at my death, then that may flow outside of the probate court. However, if I don't, then that asset will also flow through the probate court. So it's very important to look at all of your assets and understand how they flow. Probate and wills actually are going to be over those assets that don't have joint owners and that don't have named beneficiaries who receive at your death. We're always happy to look at your estate and make recommendations. If we can help you, give us a call.